Greetings everyone. In continuation to the paper discussion that we were having in the last two videos, this is the third and the last video that I am taking for the purpose of discussing the paper of Delhi Judicial Services 2023. In this particular discussion, we have three aspects remaining. One of it is Contract Act, one is Constitution, and one is Evidence, and one is Legal GK. So there are four aspects that are remaining. So we will take up those aspects in this video. That is Legal GK. Then I will take Consti. Then I will take Evidence and Indian Contract Act. These four subjects were remaining. Around 40 questions. I think 40 or 50 questions are there that needs to be discussed in these four subjects that we will do in this video. All right, English I am not taking. I've already told you that I have reservations for English because I might not be a competent person to tell you about the rules. Even if I would, I don't want to, because that is something which should be taken by, or which should be done by a expert only. So I'm not the one, so I can't claim the things, although every one of you knows about that, what to do in those questions. So you can just go through your answer key, seeing that if the answers are correct or not. And if you have any particular query from any particular question, then you can always contact Drishti Judiciary. From the website you can contact the concerned person. They might be able to help you, so you can do that. All right, so these are the four aspects that I will discuss in this video quickly. Before I move ahead, I could see that there were two questions that are still left which were not included in the slide, so I want to discuss with you in set number B. I have already told you that I am discussing set number B. This is set number B. All right, so don't get confused into it. So in set number B, question number 61 and I think question number 140, if I am not wrong. Just a moment. Yes, 140. This was not included in the slides, so I would be discussing it before even I move with the slide, because in slide we have only questions pertaining to the four subjects I have told you. So we would be doing these questions first. Question number 61, if we see set number B, question number 61 pertains to the impleadment of two persons, because when I saw that, because I was cross checking that how many questions have been done, so these two questions came up. So when I saw the slide, they were not there, so I will be doing it now. Question number 61 is: a decree for recovery of money of rupees 10 lakhs is passed against a company ABC Limited. All right. Question number 61 I am taking. So there is a decree which has been passed again against ABC Limited, a company of rupees 10 lakhs. All right. Very well. The decree holder files an execution petition and impledes Mr. A and Mrs. A as respondent number 2 and 3, since they are the promoter directors of the company. Okay. So for example, Mr. X is decree holder. So X has filed an execution petition against ABC and also impleaded A Mr. and A Mrs. So he has impleaded two more persons because he considered them, because it is the fact that they are directors of the company. But even if I see the fact, they are not supposed to come because the decree is against the company. They have no liability here. Decree can only come against the company. So even when I read that, this was the first impression that I had. So even this you should understand by reading the facts itself, that when the decretal amount is against ABC Limited, he is the one, the company is the one liable to make the payment, and company being a separate legal entity, no one else is required. Company can be sued and it can sue in its own capacity. You can always ask the money from company. No one else is required for this purpose. Also, the decretal amount is not against any of these two. It is only against the company. So company is enough. Let's see that what they want. Respondent number 2 and 3 seek their deletion. Okay, well enough. They want that we should not be implemented, we should be subtracted from the memo of parties. Subtracted means we should be removed from the memo of parties, we should not be made parties. ऑर्डर 1 रूल 10 की एप्लीकेशन डाली होगी. Is this application liable to be allowed or disallowed? Obviously it will be disallowed, but let's see. The application is liable to be disallowed as they are proper parties. Disallowed as they are proper parties does not make any sense. It should be disallowed as they are not proper parties होना चाहिए था, but I don't know, this statement is not correct. The application is liable to be okay. It should be disallowed, allowed or disallowed. So the application of them should be allowed. It should be allowed because it should not be disallowed. It should be allowed. So all right, anyhow, we are not going on that. So it should be allowed, because if you will allow the application of subtracting the parties from the memo of parties from the case, then only they will get the relief that they are asking for. The application is liable to be allowed, yes, as they were not the defendants in the suit before the trial court, correct, and are not liable for payment of the decretal amount. That is what we were understanding. They are not liable to pay the decretal amount because it is against the company only, and they were not the parties in the trial court. So why they are asking to come in execution? Execution is just a formality. It is something in consequence of a decree. It is not a case in itself. This is correct, but let's see. The application liable to be allowed subject to their undertaking that they will pay the decretal amount if ABC Limited fails to satisfy the decree. No such condition can be put by the executing court, because such kind of condition is something which is going behind the decree. The decree does not say anything like that. So there is no guarantee of directors behind the non-payment of money by company. So this condition cannot come. This is wrong. The application is liable to be disallowed. We do not have to even see this because it should be allowed. So 2 is your answer. 61 ka 2 is your answer. Question number 61, answer is 2. All right, देख लीजिएगा 2 ही होना चाहिए. Then we have question number 140. It was also remaining. Although I could not get the exact figure out of it, that how to interpret this particular question, but let's see. Even I have I should be truthful enough to tell you that certain things that we have to find out. Question number 140 pertains to arbitration. This was pertaining to the impleadment, that means order 1 rule 10. So it was CPC. Section 60, question number 61 was CPC. Order 1 rule 10 की application की बात कर रहे हैं. Plus we have to also understand the other aspect of impleadment, that if it is not included in the trial court, why you are bringing them in the executing court? You are going behind the decree. You can't do that. Behind the decree means you are not understanding the value of the judgment that has come already. Against an award passed in a domestic arbitration at Delhi, a petition under section 34 of the Arbitration and Conciliation Act can be filed before only High Court, any district court, before the commercial division of the High Court or the commercial courts, having territorial jurisdiction over such arbitration and depending on the specified value of the dispute. This is something which is true of commercial courts, Commercial Courts Act, but here it is not saying anywhere that if it is a commercial arbitration or what, because it just says against an award passed in domestic arbitration at Delhi, a petition under section 34 of the Arbitration and Conciliation Act can be filed before only the High Court, only any district court, any district court is not the option. It should not be the option. Then before any civil court having territorial and the pecuniary jurisdiction over the arbitration, it cannot also be filed before a civil court, because civil court has no jurisdiction in the arbitral proceedings. Arbitration is an arbitral tribunal, and against this you can go to only a higher authority. So 2 is not an option, 4 is not an option. Out of this, only the High Court, I failed to understand this feature in the section. Before the commercial division of the High Court or the commercial court having territorial jurisdiction over such arbitration and depending on specified value of the dispute. This looks like a justifiable option. I don't know what is the answer in the answer key, but this looks like a justifiable. That means a better option than all. So from my side it is 3. 140 का जो answer है वो 3 है. Although maybe I have mistaken or maybe I have ignored that where it is specifically written. So I have my reservations for this, but looking at the texture of the question, I could say that this is option number 3. It could be 1 or 3. I have a little doubt, but 3 is a better option. So we are going towards. Similarly, I could say you that in the first video, if you have seen that video, in that there is a question for CRPC pertaining to section 167, that the person is not arrested and detained. It has come before the court. Now there are conflicting opinions on this, because when I was discussing it with several persons, because this is something which is not written anywhere, not in the Bare Act. You would find this only as an observation in the cases. Now you cannot have a specific case pronouncing the same fact, only if we can get one. So when I was discussing that particular question, even there I could find out that if we see the object of section 167, it protects the person from launching into the jail unnecessary once he is put into the custody, so that he just comes out after 60-90 days if the investigation is not over from the date of the custody. So if we see the object, the answer is correct that we marked. But if we see the language, the language says that the remand, before the remand, no diary was shown, no occurrence report was there. So that means there was a procedural flaw. So if there is a procedural flaw, plus the person is not arrested and detained, he has surrendered, then in that case, will section 167 apply? Few are saying that it will not, it should not apply. But the thing is that once you are in custody, if investigation, otherwise if the people who are surrendering before you does not make any sense, it does not mean that occurrence report and diary is something which is quintessence of sending someone to custody. When he is in custody, the magistrate has sent him to jail for what? Or by seeing what material? You just can't send anyone to jail. So that means he has been sent to judicial custody. There he found out that there is some material out of it. It is just a matter of procedure that you have to get an occurrence report and the general diary entries. So you may eventually get it, but that person should not be in the jail unnecessarily if the investigation is not completed, as the case may be. So looking at the object and the general idea, it is correct that he must be released. Otherwise, these kind of doubts, they come, and they have put the questions in such ways. So these are the questions in which you can always either can leave or you can just mark by your own wisdom, and the wisdom is correct. So don't worry. It is always highly recommended from my side that in such kind of questions you must leave the question. देखो, question छोड़ना कोई गलत चीज नहीं है when there is negative marking. If there is no negative marking, then you can play. But knowing everything is not your take. It's not something that you must know each and every question properly. I am discussing it with you. How can I tell you that there are few questions even where I have to do some research and to see that what is happening. For example, in the aspects of arbitration or commercial courts, you have to see these things because you do not otherwise read that so exhaustively. But otherwise they were easy. I could see them that only by looking at it and general look over the provision, you can get that. They were very straightforward. And the questions that we are going to deal today, they are also, I have seen that all the 4 subjects were very easy. Very easy means you should have done all these 50 questions correctly if you have read it properly. If you have read the Bare Act properly, because no conceptual questions have been asked. No such concepts have been asked. For example, in CPC. In CPC, they have asked good questions. In arbitration also, they have taken you to places. If you had the exhaustive reading, in that case, you will be able to attempt this question paper very well. There was no problem in that. Legal GK was very easy. I don't know about English. I have not read that. Legal GK was English. The legal GK was easy, and contract was very easy. Again, consti was very easy. Direct questions are asked. Evidence. When I read the questions in one go, that what kind of questions have come, you can just recall everything that what they are asking. Clear? So 140 cup from my side, the answer is 3. I hope you have understood. Now let's go to the slide. Okay. In the year 2019, the erstwhile state of Jammu and Kashmir was bifurcated into, now who does not know about this Reorganization Act, that they both are made union territories. Kahin hai the union territory of Jammu and Kashmir and the union territory of Ladakh. You do not have to see anything else. 4 is your answer. The legal GK was very, very easy. The judgment of the Supreme Court in Vishakha versus State of dealt with guidelines related to prevention of sexual harassment of women in workplace. Who would not know this? You don't even have to read others. Domestic violence नहीं, welfare of business नहीं, इस prevention of sexual harassment इसके लिए act भी बन गया है. The largest bench of Supreme Court in Keshwanand Bharti, everyone knows 13. It should be 1, 2, 3. 3 is your option. Sorry, वो ऊपर नीचे हो गया, कोई बात. This is second option. This is 2. Okay, 2 ही आपका answer है. This is 1, 2, 3, 4. They have written it like that, but 2 is your option. Okay. I have the question paper, so don't worry. I'll cross check whenever I feel like. Which is the largest high court of the country in terms of sanction strength of judges? Judges की sanction strength depends upon the population of the state. So that is why you will see that the maximum population belongs to Uttar Pradesh. So Allahabad High Court. 4. Clear? 4 is your option for 4. The recent decision of Supreme Court in Supriyo is about Supriyo versus at Supriya. Supriya at Supriyo versus Union of India. Justice D.Y. Chandrachud, the Constitution Bench has given the judgment verdict in same-sex marriage. ये रहा. Decriminalization of homosexuality is Navtej Singh Johar. Both the above नहीं हो सकता. Who was the first Chief Justice of Supreme Court of India? Who does not know this? First is your answer. Justice Harilal Jekusindas Kania, something like that. Harilal J Kania. It's the J is something like that, Jekusindas or something like that. I'm sorry if I am wrong. I don't know. Please look at that. But it is J Kania. The doctrine of stare decisis relates to, stare decisis is that everyone is bound by the judgment of the Supreme Court. It relates to judicial precedent. Stare decisis, Article 141. Article 141 of the Constitution of India. Very easy. The bill which was introduced by the government in Parliament seeking to replace the Indian Evidence Act but now stands withdrawn recently is called Bharatiya Nagarik Suraksha Sanhita. This was IPC. Bharatiya Sakshya Bill. Sakshya is evidence. So this is what it is. Bharatiya Nyaya Sanhita. Then I think Nyaya Sanhita is IPC and Nagarik Suraksha Sanhita is some CRPC. Bharatiya Dand Bill is not there. Sakshya Bill. Sakshya means evidence. So it should be 2. Very easy. The recently enacted 106th Amendment to the Constitution provide for 1/3 seats in various legislation to be reserved for women. Which of the following legislative bodies is not included within the scope? You are reserving the seats for women in elections. So, state, if you talk about elections, then it is for Parliament. They are asking legislatures to be reserved for women. So it would be that in which elections are not happening through people. So state legislative assembly, Lok Sabha, yes. Lok Sabha के लिए तो है ही reservation. State legislative assemblies, yes. Legislative assemblies के लिए है, legislative council के लिए reservation. As such नहीं हम बोल रहे. Rajya Sabha is not elected directly, so नहीं. Legislative Assembly of Delhi ये तो यही हो गया. So this is the answer. 3. 9 is 3. Res ipsa locator means, res ipsa locator is fact speaks for itself. कहीं लिखा है, thing speaks for itself. Here 4. Very easy. The term ceteris paribus means all other things remaining same, extreme circumstances, an admission of guilt, a position of authority. Ceteris paribus is sometimes used in the judgments, sometimes used by the jurist to say that if there are certain variable terms, variable means things that are flexible, not fixed, and there are certain things that have to be fixed. That means if there are 5 ingredients, out of which 4 are static, 1 is flexible, you can remove that one and bring the other. Then you say that this event is ceteris paribus. Ceteris paribus means that all other things remaining the same, one thing can change or few things can change. That means if any change has to happen, rest of the things remaining the same, you say that this is ceteris paribus. Ceteris paribus, that means all other things remaining the same. Very rarely you use these terms, but otherwise they are used in judgments to talk about those situations in which you just talk about those variable factors which may change but other things remains the same. So this situation is known as ceteris paribus. It is just a Latin phrase that you use, not that important. What was the total membership of Constituent Assembly of India? It was 389. 3 is your answer. उसका हमने option is 1. 192 का 1 है. 250, 335, 389, 410. Total membership 389 थी, which included everyone, all the electorates. Then there was shuffling after independence and all those things. What is the minimum number of witnesses required to prove a fact under the Indian Evidence Act? There is no number of witness, everyone knows, because we talk about the quality of the witness, not the quantity. So there is no number of witness that we require for the proof of a particular thing. For that purpose, you have section 134 which talks about this. Section 134, if you will read, you will see that there is no particular number is prescribed. 4 is your answer. Very easy. There is no explanation required on this too, because they are asking that directly. If we come to the next question, Selvam went on a trek in the Himalayas and went missing, and neither his family nor his friends heard from him for many years. What is the number of years after which it can be presumed that he is dead under the Indian Evidence Act? If you know about section 107 and 108, section 107 and 108 read together in Indian Evidence Act will give you the avenue that if you have to found someone alive, section 107 applies that burden of proving death of a person known to have been alive within 30 years. If he is known to have been alive within 30 years, you would consider him to be alive. Then you have to prove that he is dead. You have to prove he is dead. Then you have to say that from the past 7 years, he has not been heard of normally by the persons who would otherwise know about him. That is given under section 108. 7 is your answer. 2. George is on trial for the murder of his neighbor Victoria. George informs his lawyer Pankaj before the bail hearing he is in fact guilty of murder. Pankaj, during the course of defending George, also comes to learn that George is plotting to kill Sophia, who is his girlfriend. Which of the following is true? George's confession to the murder of Victoria is privileged communication, but his intention to murder Sophia is not protected from the disclosure. They are talking about the privileged communication between a lawyer and a client. It is covered under section 126 professional communications. 126, 127 read together although, but directly section 126 Indian Evidence Act applies on this particular feature, and there whatever advice and whatever information you get for the purpose of defending your client, that is privileged. But if you get any information with respect to the doing of anything illegal, not pertaining to the case but otherwise, then that is not privileged. If you want me to read section 126, I can do that quickly for you, so that you get even the proviso that we are talking about, because it is talking about two situations. Quickly I read that for you. That is, no barrister, attorney, pleader or vakil shall at any time be permitted ही नहीं दोगे उसको, permitted unless with his client's express consent. Only when the client says that okay, you can speak about what I have told you, he will not be allowed to do that. To disclose any communication made to him in the course and for the purpose of his employment. What is in the course and purpose of his employment? Because he is hired as such for the purpose of giving counseling, and for counseling he has to be told the truth. And if he will go and depose before the court that I have heard this, because that is a confession extrajudicial. If your client is speaking before you that he has committed the crime, that is a confession. It is relevant under section 24. And it is an extrajudicial confession. I can always depose that he said that to me. I will not be allowed unless he give express consent to it. Made to him in the course and for the purpose of his employment. What he did is that for the purpose of my employment, that I represent him, that he told me all these things. He did not tell me otherwise. Not a passing reference that he made to me. They made to me because he wanted me to do something for that. Such barrister, pleader, attorney, vakil, by or on behalf of his client, or to state the contents or condition of any document with which he has become acquainted in the course and for the purpose of his professional employment, or to disclose any advice given by him to his client in the course and for the purpose of such employment, provided that nothing in this section shall protect from disclosure. Proviso aa gaya. Any such communication made in furtherance of any illegal purpose. Made in furtherance of any illegal purpose. That means what you have done, you have done. But if you have made any communication that is in furtherance of any illegal purpose, that means you are about to do something. See here, both the things are present. George is on trial for murder of his neighbor Victoria. George informs his lawyer Pankaj before the bail hearing he is in fact guilty of murder. So he confessed to the crime. Pankaj ko bata diya, he confessed to the crime that I have killed Victoria. Pankaj will not be allowed to depose because he has already done that. Pankaj, during the course of defending George, also comes to learn that George is plotting to kill Sophia. That means he is doing something in furtherance of something illegal. That means he's now doing something. For that, he is duty bound to come to the court and depose that he is going to do something wrong. Who is girlfriend? Which of the following is true? So George's confession to the murder of Victoria is privileged communication, which is correct, but his intention to murder is not protected, which is also correct according to the proviso. मुझे तो यही ठीक लग रहा है, आगे पढ़ लेते हैं. George's confession in respect of murder of Victoria as well as his intention to murder Sophia are both privileged communication and protected from disclosures. No, according to the proviso, not. Neither George's confession nor his intention to murder Sophia are protected. ऐसा तो है ही नहीं. 126 का क्या काम फिर? George's confession to the murder of Victoria is not a privileged communication. ये भी नहीं है. तो obvious सी बात है, तो पहला ही ठीक निकला. तो 28 का 1 is your answer. It was very simple. These all four were very simple. Which of the following constitutes secondary evidence? Copies made from the original by mechanical processes, which in themselves ensure the accuracy of the copy. Correct. Oral accounts of the contents of a document given by a person who has seen such document. When you talk about secondary evidence is dealt, I tell you directly that it is dealt under section 63. What are secondary evidences? And if we read 63, we will see that what options do we have. 62 is primary evidence, 63 is secondary evidence. Secondary evidence means and includes certified copies, copies made from original by mechanical process, बिल्कुल सही है. Copies made from or compared with the original, ऐसा कोई तो है ही नहीं. Oral accounts वाले पे आ जाते हैं. Fifth is oral accounts of the contents of document given by some person who has himself seen it. ये भी ठीक है. Both 3 is your answer. डायरेक्ट सवाल आ रहे हैं इसमें, ये सारे फैक्चुअल है, इनमें कोई कॉन्सेप्ट नहीं लग रहा, कोई दिमाग नहीं लगाना पड़ रहा है, जो आपको जानते हो वही है. Sylvester is arrested under suspicion of having committed cheating and forgery. In what circumstances will his confession made in the custody of a police officer be proved against him? Custody of a police officer, you have to go to section 24 and 25, 26. 24 talks about confession, the relevancy. 25 says that no confession made to a police officer shall be proved as against a person. It is very clear, but here let's see what are the options. If it is made in the presence of a police officer above the rank of deputy commissioner, ऐसा कुछ नहीं होता. If you are making it to if you are making it to a constable or to a DGP, the highest rank, from constable to DGP, everyone is a police officer. Everyone holds the office. That everyone is an officer. That means having the authorities, having the power. तो ऐसा नहीं कि कांस्टेबल ऑफिसर नहीं होता, because you generally consider that officers are above the rank of it starts from the rank of ASI. It is not the case. The police officers are from constable to DGP. Everyone is a police officer. And so if you make confession before them, it is not proved. It cannot be proved in the court because of other things that we will discuss when we are discussing that topic. If it is made in the presence above the rank of DCP, ऐसा कुछ नहीं है. If it is made in the immediate presence of magistrate, 25 में तो ऐसा कुछ नहीं है. 26 में देखते हैं. No confession made by any person whilst he is in custody of a police officer unless it be made in the immediate presence of a magistrate shall be proved as against such person. In custody, if it is made, और यहाँ पर क्या लिखा है, having committed cheating, in what circumstances will his confession made in the custody? See, made in the custody, that means directly section 26 will apply. 26 Indian Evidence Act. We do not have to even see 25. So this If it is made in the presence of police officer above the rank of DCP, ऐसा नहीं लिखा. If it is made in the presence of magistrate लिखा. If it is made in the immediate presence of magistrate, ऐसा ही लिखा. Immediate presence लिखा. Direct question है. 2 is answer. All of the above नहीं हो सकता. None of the above नहीं हो सकता. 2 is your answer. Direct question आ रहे हैं. As per the Indian Evidence Act, admissions are conclusive proof of the facts. Not at all. It cannot be. Conclusive proof has to be expressly given. May operate as a estoppel against the person who makes them. This is correct. This is totally correct as far as I remember. And admissions may act as a estoppel section 31. It is not conclusive proof but may estop. App operate as estoppel. Section 31 says so. 53 का 2 direct सवाल है. How many years need to elapse before the electronic record in proper custody give rise to a presumption as to the correctness of digital signature under Indian Evidence Act? Okay, this is based upon the presumption, and here you can see section 90A talks about electronic records. Section 90A, and this would be 5 years. Direct सवाल. 1 is your answer. Direct, no problem. I have no analysis, only factual. Communication during marriage between spouses is generally protected from disclosure, subject to exceptions, under which section everyone knows about it. This is section 122. There is, ये तो ऐसे यूपी वाले सवाल हैं. यूपी में ऐसे ही सवाल आते हैं ना, डायरेक्ट सवाल पूछते हैं. Communication during marriage is 122, based upon fact totally. Fill in the blank. When a man has not been heard of for 7 years by those who would have, यहाँ पर एक blank होगा. Who would have, यहाँ blank है. Who would have heard of him if he had been alive? The burden of proving that he is alive shifts to the person who affirms it. ये वही तो है section 108. अभी तो हम बता रहे थे 107 और 108. तो 108 में जाके देखें. The question is whether a man is alive or dead, and it is proved that he has not been heard of 7 years by those who would naturally have heard of him. Naturally यहाँ पर n. Naturally हाँ ये 4 is your answer. यहीं पे गैप होगा, यहाँ पर गैप होगा और यहाँ naturally होगा, और this is the 4th is your option. 56 का 4. Very easy. Electronic record produced before court is treated as documentary evidence. Everyone knows about this. इसमें तो कोई दिमाग लगाने की जरूरत भी नहीं है. Electronic record है तो documentary ही होना है. Evidence given by a dumb witness is in writing or by sign language in open court, and reduced in writing is oral evidence. Everyone knows about this. Dumb witness पे section भी है आपका. Section 119 witness unable to communicate verbally. Section 119 में लिखा भी हुआ है oral evidence. If you want, we can just go by it once. 119 लास्ट में लिखा है as by writing or by signs, but such writing must be written and the signs made in the open court. Evidence so given shall be deemed to be a oral evidence. ठीक है, 2 is your answer. Burden of proof in a suit or proceeding lies on the person. ये तो डायरेक्ट सवाल है फिर से सेक्शन 101 का. Section 101 talks about burden of proof, and the statement used there is that who want judgment for himself. If we see whoever desires any court to give judgment as to an illegal right, who would okay, dependent on the existence of facts which he assert must prove. When a person is, it is said the burden of proof lies on that person. Whoever desires any courts to give judgment, and then the onus, the burden of proof in a suit or proceeding lies on that person. It is section 102. Burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. This is talking about onus. This statement is directly taken from section 102, and who would fail if no evidence at all is given on either side. 4 is your answer. Direct सवाल आ रहे हैं, इसमें कुछ तो देखना ही नहीं पड़ रहा. Which of the following is true for burden of proof in civil and criminal case? Everyone knows about this. Civil case preponderance, criminal case beyond reasonable doubt. In civil case preponderance, criminal case यही ठीक है. Preponderance in both no, beyond reasonable doubt both no. There is no, ऐसा तो हो ही नहीं सकता. 1 is your answer. इसमें तो it's very easy. जितना मेहनत आपको अभी पिछले वीडियो से पिछले वीडियो में दिखा होगा, इस वीडियो में कोई मेहनत नहीं है. फॉर ए कंडक्ट टू बी रेलिवेंट, ये 50 क्वेश्चंस आपके अगर इसमें से आपने मैक्सिमम 45 भी स्कोर किया है तो यू हैव गॉट अ गुड एज, because most of them would be marking it correctly. So but you have to be like more into 45 to 50 के बीच में. For a conduct to be relevant which shows or constitutes some motives or preparation for any fact in issue relevant fact under section 8, the conduct must be prior subsequent, दोनों ही होते हैं, maybe previous or subsequent. Yes, it should be both. 3, conduct is relevant. A fact is said to be proved when a देखो proof of fact तब माना जाता है जब कोर्ट उसको विश्वास कर ले. इसका हवाला आपको सेक्शन 3 में मिल जाएगा. सेक्शन 3 में प्रूव्ड डिफाइंड है. A fact is said to be proved when, after considering the matters before it, the court either believes it to be exist or considers its existence so probable. Witness testifies, no, court believes it to exist. सीधा लिखा हुआ है, सीधा लिखा हुआ है, कुछ देखने की जरूरत ही नहीं. This is your answer. A will can be proved under section 68 of Indian Evidence Act by calling. 68 पढ़ लो, क्या फैक्ट लिखा है. Proof of execution of document are required by law to be attested. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for the purpose. Here, पहला ही है, one of the attesting witness. Advocate नहीं, stenographer क्यों? यही होगा, बस one is the answer. All of the above तो हो ही नहीं सकता. साफ लिखा है ना. They are giving you the reference to section 68, so you have to remember the contents. If a court puts question to a witness under section 165 of Indian Evidence Act, then parties have a right to object, parties have a right to cross-examine. 165 में ऐसा कुछ भी allowed नहीं होता. But let's see the address. 165. Last में देखिए. Neither the parties nor the agent shall be entitled to make any objection to such question or order, nor without the leave of the court to cross-examine. No objection, no cross-examine without leave of the court. ऐसा कुछ लिखा है, leave of the court नहीं, ठीक है. Both. If the court puts question, then neither one nor B. This is your answer. 4. Because if a court put questions to a witness under this, then parties have right, no. Parties have right to cross-examine, no. So neither one nor 2. 4 is your answer. बहुत स्ट्रेट फॉरवर्ड क्वेश्चन है, एक भी क्वेश्चन में मेहनत नहीं है. अंडर द इंडियन एविडेंस एक्ट, कोर्ट मस्ट टेक जुडिशियल नोटिस ऑफ. दिस इज बेस्ड अपॉन सेक्शन 58 दैट टॉक्स अबाउट जुडिशियल नोटिसेबल फैक्ट, एंड देन इन सेक्शन 57, sorry, not 58, section 57, there are list of subjects of which the judicial notice should be taken off. And all laws in force in India, obviously all seals of English courts लिखा ही हुआ है सब, all laws लिखा हुआ है. Then all seals of which English court is written there. This is 1, then it is 6, ये 1 में लिखा है, ये 6 में लिखा है. All public acts passed by parliament, ये 2 में लिखा है. तो ये तीनों ही है. All of the above is the answer. 4. चौथा आपका आंसर. Radhe is summoned by the plaintiff only to produce a document. Which of the following statement is correct? देखिए, किसी को डॉक्यूमेंट देने के लिए अगर आप समन करते हैं तो वो डॉक्यूमेंट दे के चला जाएगा, उसको डिस्चार्ज कर दिया जाएगा कि आप जाइए, डॉक्यूमेंट आ गया है. आपका कोई वो विटनेस नहीं बुलाया जा रहा है, डॉक्यूमेंट देने के लिए बुलाया जा रहा है. He can be cross-examined by the plaintiff for what? He can be cross-examined for what? He can be cross-examined by both. For what? He cannot be cross-examined. Yes. Because you are calling him only for the purpose of giving document. Why will you cross-examine him? He is not a witness. He is only a carrier. वो कैरी कर रहा है, वो ट्रांसपोर्ट कर रहा है बस डॉक्यूमेंट आपको. उसमें उसको क्यों आप करेंगे? As per section 23 of Indian Contract Act 1872, a consideration or object of an agreement is unlawful if there are 6 grounds in section 23 which you have to remember. Fraudulent, court considered as immoral or against public policy. Then there are other grounds also in section 23 which makes it prohibited by law, or it will defeat the provisions of law. There are 6 grounds on which you can say that consideration or object is unlawful. The court regarded, ये तो है, it of such a nature that if permitted would defeat provisions of law, ये भी है. It involves implies injury, ये भी है. All of the above. 4 is your answer. Indian Contract Act भी बड़ा आसान है. Party seeking appointment of an arbitrator through the High Court or its designate shall make a request under. I think this question was also not taken care of yesterday in this slide. This pertains to arbitration. Party seeking appointment of an arbitrator through the High Court or its Designate shall make a request under. Okay. This is 11.6. Third is your answer. It depends upon, like, it is a factual question again. I'm very sorry that this I missed even this question in the last slide because it was not there. So I'm very sorry. This question is anyhow in the slide now. The preamble of the Constitution of India resolves to secure to the citizens. Everyone knows about justice, liberty, equality, fraternity. First is the correct answer because it is duly effort. Justice, liberty, security is not there. Justice, equality is not there. Justice, liberty, equality, fraternity. This is the correct sequence. Okay, security is here, so independence is not there. First is your answer. Anyhow, आँख बंद करके आप सही चीज मार्क करेंगे. Which of the following rights are not included under Article 19? Freedom of speech and expression तो है ही 19(1)(a). Form association B ही है. Right to reside, settle anywhere ये last है. Right to practice any, right to, अच्छा I'm sorry. Right to practice तो है ही any profession. Right to reside and settle anywhere in India नहीं है, in the world लिखा है. Okay, तो ये तो कैसे ही हो जाएगा ना? Which is not included. नहीं, ये तो included नहीं है. World नहीं है जी, India है. India होता तो मैं confused हो जाता अभी. Because that is why I made it right. I did not see world. Because right to practice any profession is also there. Which of the following rights are not guaranteed in Part 3? Right to education है बिल्कुल 21 है. Right to minorities to establish administrative बिल्कुल है जी ये तो 25, 26, 27, 28 also. Right to constitutional remedies 32. Right to stand for election to parliament ये right नहीं है आपके पास. 4. Under Article 22 of the Constitution, every person who is arrested and detained in custody is to be produced before the nearest magistrate within 24 hours. 24 hour में produce करना होता ना. Every person who is arrested and detained in custody to be produced before the nearest magistrate within 1 week नहीं है, 3 days नहीं है, immediately भी नहीं है, within 24 hours. None of the above. 4 is your answer. The procedure for amendment of Constitution under Article 368 of Constitution requires an amendment to be initiated by introduction of a bill in either House of Parliament, introduction of a bill in only the Lok Sabha, introduction of a bill in either House of Parliament or Legislative Assembly of any state, no. Resolution of the concerned government, not at all. It could be any one, if I am not wrong. 368, let me just cross check. 368, if I am not wrong, it is either House of the Parliament because it does not require only a single house to do that. Either House of the Parliament. Yes. 1 is your answer. 368 says so. 368(2). 368(2) says so. In view of Article 239AA तो दिल्ली का है of the Constitution, the city of Delhi is a state with the legislative assembly. State नहीं है. UT with the legislative assembly, yes. UT without, no. हमारे legislative assembly है. State without, no. State तो है ही नहीं. UT. It's a UT with the legislative assembly. Everyone knows that. The fundamental duties enumerated in Article 51A of Constitution includes safeguard public property and to abjure violence, value and preserve, yes. To defend country, render national service, बिल्कुल सही है. 4 ही होना चाहिए. ये सारे ही हैं. सब fundamental duty है 51A में. Minimum age for eligibility for election to the office of President of India is, देखिए वैसे तो he should be also eligible to be member of लोक सभा तो 25 होता है लेकिन 35 लिखा हुआ है specifically, तो 1 is your answer. It is given under Article 58. 58 में देखना है, मिलेगा ये. Under Article 79 of the Constitution, Parliament for the Union of India consists of Parliament consists of President and the Lok Sabha Rajya Sabha. President of India 2 houses, यही ठीक है. President of India 2 houses and Council of Ministers, नहीं. Council of States and House of People, no. President has to be there, no. First is your answer. Does the Constitution provide for an opinion to be rendered by any court on a question of law or fact other than by way of adjudication of lists? This wants to ask you that if apart from adjudication of list means apart from bringing a case before the Supreme Court, can Supreme Court adjudicate upon any matter that an opinion to be rendered by any court on the question of law or fact? On the question of law or fact, if an opinion can be rendered by Supreme Court other than the way of bringing a petition before the court. If you remember, it is the advisory jurisdiction of the President under Article 143. If you know. No to nahi ho sakta. Yes, the High Courts can exercise advisory jurisdiction on reference of Governor. This is also true, but other than by way of adjudication, yes, the High Courts can exercise advisory jurisdiction on a reference by the Governor of the concerned state. ये true है. Yes, the Supreme Court can exercise advisory jurisdiction on a reference of the President of India. Yes, this is also true. Yes, the Supreme Court can exercise advisory jurisdiction on a request of any member of Parliament. No, this is not true. ये तो no तो हो ही नहीं सकता. तो 2 और 3 है. Does the Constitution provide for an opinion to be rendered by any court on a question of law or fact other than by way of adjudication of list? Advisory jurisdiction on a reference of अच्छा okay ठीक है. There is no advisory jurisdiction of the governor, so this should not be the okay. This third is your answer. I'm sorry. So advisory jurisdiction is by the President of India to the Supreme Court. Governor does not have any advisory jurisdiction, so this is wrong. I'm sorry, I got confused. Which of the following offices are not provided for in the Constitution of India? CAG तो है, Article 148, Attorney General Article 76, Election Commission भी है आपके पास पूरा 325 से लेके सॉलिसिटर जनरल नहीं है, ये आपकी स्टैट्यूटरी पोजीशन है. 4 Solicitor General, additional Solicitor Generals are not given in the Constitution. They are made by the government. The preamble of the Constitution constitutes India as a sovereign, socialist, secular, democratic republic. Which of these words were not in the original preamble? ये नहीं थे. Socialist और secular ये बाद में डाले गए. ये 42nd Amendment में डाला गया था. Socialist and secular है कहीं? ये रहा. Third is your answer. Initially, it was only sovereign democratic republic. Then socialist and secular word was inserted. As per Section 52 of Indian Contract Act, where the order in which reciprocal promises are to be performed is expressly fixed by the contract, they shall be performed in that order. Correct. Where the order is not expressly fixed by the contract, they shall be performed in the order which the nature of transaction requires. Correct. ऐसा ही exactly लिखा हुआ है Section 52 में. Exactly. As per Indian Contract Act, an agreement in restraint of trade is void. It is void to that extent. Yes. Is में यहाँ पर gap है. Void है. 1 is your answer. 22 of Indian Contract Act, a contract caused by mistake of one party as to matter of fact. देखिए जब एक पार्टी matter of fact में mistake करती है तो वो legal होता है contract. But the term written there is not voidable. ये रहा जी word 2. Not legal तो नहीं हो सकता, not void भी नहीं है, not voidable is the exact term written there. As per Indian Contract Act, a contract to perform the promise or discharge the liability of a third person in case of his default. ये हमेशा ध्यान रखना. To discharge the liability in case of default, जब भी ये आ जाए तो ये guarantee का contract है. To make good the loss is indemnity, but in default to discharge the liability is guarantee. Under Section 130 of Indian Contract Act, a continuing guarantee may at any time be revoked as to future transactions by notice only. Without any notice, by notice यही ठीक है. Without any notice, by notice to debtor को क्यों दोगे? Creditor को दोगे ना. Without any notice to the debtor, यही है. 1 is your answer. Sarita promises to deliver goods to Babita on a certain day on payment of rupees 20,000. Sarita dies before that day under the Indian Contract Act. देखिए जब भी ऐसा कोई कॉन्ट्रैक्ट हो जिसमें यू हैव एन एवेन्यू ऑफ डूइंग द थिंग्स बिकॉज द इंटरेस्ट डिवॉल्व्स अपॉन यू आफ्टर द डेथ ऑफ द पर्सन हु मेड द प्रॉमिस. इफ द इंटरेस्ट डिवॉल्व्स अपॉन यू देन यू आर लायबल टू परफॉर्म द प्रॉमिस. ऐसा नहीं होता कि जिसने प्रॉमिस किया वो गया तो कॉन्ट्रैक्ट भी गया. कॉन्ट्रैक्ट में राइट्स और इंटरेस्ट अगर डिवॉल्व कर जाते हैं और वो पर्सनल क्वालिफिकेशन पे डिपेंडेंट नहीं है तो आप उसकी स्पेसिफिक परफॉर्मेंस मांग सकते हैं. इसमें SRA का भी रोल आ जाता है. The concept of specific performance of contract. So here, if I see the question, I could very well understand that yes, it can be made enforced. Sarita's representative are bound to deliver the goods to Babita, and Babita is bound to pay 20,000 to Sarita's representative unless any contrary intention appears from the record. This is true. Sarita's representative not bound. Sarita's representative not bound. None of the above. यही सही है. ये बिल्कुल करेक्ट प्रेपोजिशन ऑफ लॉ है और ऐसा दिया भी गया है इंडियन कॉन्ट्रैक्ट एक्ट में. There is one question that when I skimmed through the question paper again, there is one question that we missed to include it in slide. Was question number 155, set B. I did not see this question because even here when I was going through, it just caught my attention. A had advanced a loan of rupees 1 lakh to B. Okay. A has advanced loan of rupees 1 lakh to B. A ने B को 1 लाख रुपया दिया है on 1/1/2009, 1 जनवरी 2009 को, ठीक है. Which was to be repaid on 31/12/2009. 31/12/2009 को रीपे करना था, मतलब 1 साल बाद रीपे करना था. On 31/10/2012, 31/10/2012, a legal notice was issued by an advocate on behalf of A and served on B, demanding immediate repayment of the debt. A ने एक लीगल नोटिस दिया. देखिए ऐसे ही बनते हैं नोट्स, फटाफट आप इसको बनाएंगे तो आपको इशू समझ में आएगा, फिर आप ऑप्शंस देख पाएंगे. तो दिस इज द डेट ऑफ पेमेंट ऑफ डेट, दिस इज द डेट ऑफ रीपेमेंट ऑफ डेट. दैट मीन्स यू हैव टू रीपे इट, वापस देना है. 31/10/2012, दैट मीन्स आफ्टर बिफोर 3 years, 2 साल 2.5 साल बाद 31 अक्टूबर 2012. 9 से 12 देखें तो 3 साल बनते हैं, लेकिन 9 से 12 में 12 तारीख हो गई. दैट मीन्स फॉर द रिकवरी ऑफ मनी यू गेट 3 years. दिस यू नो, इट इज बिफोर 3 years दैट यू डिमांडेड द मनी. लीगल नोटिस वॉज सेंट बिफोर 3 years. Served on B, demanding immediate repayment of the debt. B, through an advocate engaged by him, sent a reply to the advocate for A on 30/11/2012. 30/11/2012, B replied through advocate. B replied through advocate. ठीक है, B ने रिप्लाई कर दिया 1 महीने बाद, ये भी ठीक है. Refusing to pay for want of resources. B refused to pay. He says that I will not be able to pay because I don't have money. Refuse to pay. यहां तक समझ सुन के ही मुझे समझ में आ रहा है, मतलब पढ़ के ही समझ में आ रहा है कि एक्नॉलेजमेंट की बात होगी. Citing this as acknowledgement, see, citing this as acknowledgement of debt, A filed a suit for recovery on 1/2/2013. 1 February 2013. Because the 3 years for the recovery of money after it got accrued on 31/12/2009. Within 3 years they have to file the suit for recovery of money. If they're not filing within 3 years, then it is lapsed by the time the suit cannot be filed. But he filed it on 1/2/2013, saying that it has been acknowledged on 30/11/2012 when the reply was refused. So that becomes the acknowledgement of the debt. So once there is an acknowledgement of the debt, you get 3 more years. Now it is within limitation if you get the protection of section 18. It is not 3 more years if you do not get that protection. B takes the plea of bar of limitation on grounds that no subsequent event stops the time of 3 years once it has begun to run on 1/1/2010 refusal. Once it has begun on 1/1/2010. He is saying that after the payment got accrued, B is saying that it is barred by limitation. Although I could see that this becomes a valid acknowledgement. This is a valid acknowledgement because he refused to pay. He did not say that what money. He did not absolve the payment. He said that I will not be able to pay. That means he is admitting that he has to pay. Refusal also amounts to acknowledgement. So this is a valid acknowledgement, I tell you. But B is saying that after 31/12/2009 when it was accrued, that means from 1/1/2010, no subsequent event can stop the limitation period. He is wrong because acknowledgement is there. Let's see. Refusal to pay does not amount to acknowledgement. Refusal to pay amount to acknowledgement. Read section 18, you will get to know about the fact, because you have to acknowledge either directly or indirectly. This is indirect acknowledgement only. You must have said what money. You must have said I owe nothing to you. What are you saying? Only then it becomes no acknowledgement, because he is denying that fact. There is no acknowledgement in writing by B since the reply was signed only by advocate. Advocate is working through B. Advocate is agent of B. So it is something which is done on behalf of B. It becomes, it can be imputed upon B. There is no acknowledgement in writing by B since the reply was not addressed to A. All the factors he is saying is wrong. तो क्या आंसर होगा? All grounds are correct. नहीं, all grounds are not correct. All grounds are incorrect. All the grounds are incorrect. This is true. Ground A and B are correct. No, all the grounds are incorrect. 2 is your answer. For 155 question, 2 is your answer. I hope now I have taken all the questions, and thank you so much for bearing these 3 videos, and kindly look upon those questions. Look how you have to see. Maybe they are going to help you in the future upcoming examinations, or it will be able to make you go through the objections that you may have to file, because there are 1 or 2 objections that you may always see. There are a few objections that I have made yesterday. I think question number 93 I was confused. Question number 63 I was a little confused that I don't know what should be the correct answer. So maybe there can be an objection there, and also that 167 part, because there is conflicting opinion. But from my side, it should be that he must be granted investigation. He must be granted bail if investigation is not completed. So there are 2-3 questions in which you may be confused, that you can always submit for objections. Any query you may ask. Thank you so much for today, and thank you so very much for being with me in these 3 videos. Thank you. We'll see you again.